Hello, I'm Constitutional Attorney Katherine Henry, and today is a continuation of our mini-series on 85 of the most common criminal law terms and their definitions. So to jump right back into it, no bill. This phrase, endorsed by a grand jury on the written indictment submitted to it for its approval, means that the evidence was found to be insufficient to indict. So instead of being not guilty, they're saying no bill. There's not even enough to bring a case here. Null pros. Now, if you null pros a case, it's essentially dismissing. It is a formal entry on the record by the plaintiff in a civil case or the prosecutor in a criminal case declaring that he or she will not further prosecute the case. They're saying, I no longer am going to prosecute the case. Nolo contendere. I will not contest it. It is a plea by a defendant in a criminal case on which, like a plea of guilty, a conviction may be entered, but unlike a plea of guilty, may not be used as an admission of any other matter. So they're saying whatever the prosecution has alleged, I'm rolling with it. I'm not admitting to it, but I'm not going to contest it. Objection. The taking of an exception to a question, answer, statement, or procedure in trial, intended to focus the court's attention on some allegedly improper item of evidence or improper procedure used to obtain relief from the court. Parole is a conditional release from prison before the end of a sentence. If the parolee observes the conditions, he or she need not serve the rest of his or her term in prison. Peremptory challenge, the right of the prosecution and defense in criminal cases to dismiss a prospective juror without giving any reason. The number of such challenges is limited by statute and varies from jurisdiction to jurisdiction. Pleading is the process by which opposing parties alternately present their contentions in writing, each responding to the immediately preceding pleading of the other party, thereby narrowing the controversy until a single point of dispute emerges called the issue. It is the issue that is resolved at trial. And so the pleadings are going to be the legal documents prepared for that case that are filed with the court. Preliminary hearing. A preliminary examination, as it's called in Michigan, is a hearing before a judicial officer to determine whether there is sufficient evidence against a person charged with a crime to warrant holding him or her for trial. The Constitution bans secret accusations, so preliminary hearings are public unless the defendant asks otherwise. The accused must be present and accompanied by legal counsel, or at least offered legal counsel. Presentment. That's an informal written statement from a grand jury to the court, where they're summarizing the grand jury's knowledge and observations about a public offense with respect to which no indictment has been requested or voted on. Probable cause. A reasonable ground established after investigation or direct observation for believing that facts exist warranting further proceedings. Probation. It's allowing someone convicted of a crime to go free while their prison or jail sentence is suspended during a time of good behavior. And there's generally two different types of probation. There's either reporting or non-reporting probation. So with reporting probation, you typically have to check in every so often. Sometimes they have it scheduled like once a month or even once a week. Sometimes it's going to be random when the probation officer checks base with you to make sure that you're doing what you're supposed to be doing and not committing any new offenses. The non-reporting probation is exactly what it sounds like, where there's no probation officer that is checking in with you and making sure that you're continuing to be employed or, that you're not violating any new laws or something of that nature. Quash. That means to vacate, to annul, or to void. Reasonable doubt. Obviously, the phrase most commonly used is proof beyond a reasonable doubt. And what exactly does that mean? Well, that means that someone has to be found not guilty if, in the minds of the jurors, Guilt is not established beyond a reasonable doubt, and reasonable doubt is the highest standard of proof in any U.S. court. So, is it a mathematical certainty that something has happened, that the person committed the crime? No, there's no absolute mathematical certainty involved. But what it is it's referred to as a moral certainty that leaves no reasonable doubt in the mind of an ordinary person that the crime has been committed by the individual charged. Now, the entire burden of proof rests with the prosecution, something to keep in mind, and they have to prove every element of the offense beyond a reasonable doubt. The defendant can sit back and literally say or do nothing. They can just choose to be silent the entire time, and the entire burden of proof rests on the shoulders of the prosecutor. Otherwise, the defendant is entitled to be found not guilty.